Hold up, grab my soda cause I told you I'm colder than hell. I ain't buying what you sell, it don't ring my bell. Unless it's got the smell, you know, like grape vape. We ain't talking vapes or the color of drapes, or a gorilla in a cape. It's the good shit, just one hit. You so lit, you fall into a bit, non-bit. What's fucking funny is you're a monkey, a high school flunky, hero and junkie, obliteration of the carnation with gross castration, skewed citations by your intimations. Get real, young man, there's only one stand. You can't stand a suntan, how you gonna live on the land? Obliteration of the carnation with gross castration in skewed citations by your intimations. I'm a truth in rotation, you're a cheap imitation. Dark said hums, 808s make the ground shake. Cold as the grave, every word's a land quake. You're a flicker in a cipher, I'm the flame that won't fade. Step into the night where the shadows are made. What's fucking funny is you're a monkey, a high school flunky, hero and junkie. I'm gonna click another hit of this good shit, and I'm already it, so take over, it's been non-bit.
Thank you for joining us at Personality Inventory Mockumentary Productions. Man up, slaves, and hit those buttons, or I'll send ice.
And greetings, everybody. Keith here. Hoping everybody's having a good time, living life, enjoying life, loving life. Please hit those buttons, and don't forget, I guess I got to work on my spelling. Don't forget the PayPal link in the description to help us out with anything you can. The shit is getting expensive. And it's particularly getting expensive when they deny your certified mail. And that's what we're going to talk about. The 14th Amendment violations in our current case about a wrongful eviction turned constructive eviction, with all kinds of procedural legal errors by every participant along the way, with the exception of us doing everything in good faith, giving proper notices. First duty in law is legal notice, da-da-da-da. And we've given them notice of all these procedural errors, and they just keep on trucking forward. So let's talk about some things. First of all, let me take care of my visual here. So as you know, I recently sent a bunch of certified mailings out. Cost us $75 to send them out, and we've already got the first one back that they did not accept. Notice there's no signature on there of acceptance. They just turned around and sent it back. And this one is addressed to the Jackie R. Rath, Clerk of the District Court. And reading on the bottom, it says, urgent civil rights actions request, or civil rights actions request for audio. So we're trying to preserve the physical record, which includes the audio that they're trying to hide in a digital record. So we're going to go over some of these details here. And what I did was, of course, we got this back. We do not open this. Do not open this. This is evidence now. You do not open this. This has an original wet ink signature inside, blue ink, that was supposed to go to the clerk to help preserve the record. They denied this physical record, and they're likely going to say, well, it was electronically filed. But that's not the proper physical preservation of a physical record. That's trying to hide a physical record through a digital record that doesn't allow for blue ink signatures, proving that it was handed over to the clerk and that is in their custody, and they have a mandatory duty as to the integrity of the record. By failing to accept the physical preservation of the record, they have violated their rules. So what we did was we copied the envelope. And what we're now going to do is go back down there with a new notice to the clerk in physical form and hand deliver it ourselves. This one here, we don't need a third party to serve it. This is our right to preserve a record in dealing directly with public officers, public agents, which public service is a public trust. They are obligated to do so, and we're going to show you where. So what we did here was we got this. We're going to take this with us, and we're going to want them to date stamp this. If they refuse to date stamp this, then our next notice is going to include this with it, so that when they date stamp our next notice that we hand deliver with the blue ink signature, then that's included with it as an exhibit. Now, if they refuse that filing, in other words, if they refuse to date stamp my physical paper document, then they are again in violation of the exact same thing that we're telling them that they're already in violation of. Okay? So it's not a matter of agreement. I'm not here to agree with them. I'm here to tell them what they're doing. That's my job. That's my part in this. I have a duty to throw off a despotic government. So when I went down there the other day with that filing, to electronically file it and send all those certified records, I let them know at the end of it, when I was done doing that electronic filing, I won't shave this off until people around here start acting like true Americans, because we do not allow Hitler's willing executioners in our buildings. And then when I turned around to walk out, I had to walk in between two strapping huge deputies. And I looked at them and said, I hope you guys understand that as well. And notice, I didn't ask them if they heard me. I know damn good and well they heard me from 30 feet away. I have a voice that carries in those hallways. I hope everybody hears it from now on, because I'm holding everybody accountable. See, I'm not a First Amendment auditor, as a friend said on a recent panel here today. He's not so much a First Amendment auditor, though he will do some auditing in reference to his own private actions. I don't even do that. I'm just here to hold them accountable. My auditing is a journal that I freely express because you all have a right to know. So let's talk about what you have a right to know in regards to how these filings work. Put my screen back up. Oops. And then I got to get my document here. Yes, it is unbelievable. When you go through this case and you see how many people have violated state statute and they're all getting away with it, and all covering everybody, each other's ass, and the only ones that have been doing things right are me and my wife, you'll understand the propensity of this. And this is not just one off. This is systemic, as I've been telling you about for the last several years now. It is systemic. Now I have the opportunity to step up and show it, and that's what I'm doing. I'm doing everything I can to preserve that record so you have the ability to review it so you know. And like I said, don't believe me. Don't believe the neighbor. Don't believe the government. For crying out loud, don't believe your mother. Do your research so you know. Because I can explain it to you, but I can't comprehend it for you. It's the same thing with these clerks. I can explain it to them, but they're the ones that are supposed to have the competency to know what they're doing, to comprehend what their job is. And if they don't, I can help them understand that. But if they refuse to comprehend it in any manner, like they are doing here, that's on them. So let's get my screen share up. Let's add that. And I have to okay, this is get my font so everybody can read it. And of course, expand, hide, double check. Okay. Now this here is the original request for original audio recording. And so what we're going to do is we're going to print another copy. And we're going to include that with our next notice. They're going to get this physical copy one way or another. Okay. And says comes now the defendant. You can go back and review my previous video to see what that says. And now we're going to enter in another notice, mandatory custody of record, and notice of affidavit of refusal with motions to sanctions or motion for sanctions. And this here is the part where we're going to once again address the Iowa Supreme Court in regards to our latest filing with them, the appeal to the Iowa Supreme Court, because this lower court dismissed it at the cost of the defendant in violation of state law, and that requires a mandatory appeal and investigation subsequent to it to remand it back to the lower court to remove the dismissal and find the exact summary judgment for the defendant as they were supposed to do, again mandated by a strict statutory presumption of retaliation to do so, which they failed. Also including the fact that they turned around and again violated their rules of conduct, civil procedure, in allowing for a voluntary dismissal after the hearing was already had. Therefore, the voluntary dismissal was barred, particularly when it was supposed to hand down that summary judgment, whether it be for the defendant or the plaintiff, and doubling it up, the magistrate, instead of doing so, took it under advisement, which means now the chief judge has a mandatory, strict statutory mandatory duty to investigate as to why the case was diverted from adjudication. So there's all kinds of violations happening, and they're all dismissing their own violations. We're not going to allow that to happen. Notice to clerk. On 3/4/2026, the clerk of court refused the physical delivery of our request. For audio, see attached photo of the certified mail envelope, which was refused by this office on 3/4/2026. We are requiring that both the filing and the evidence of the refused mail be documented in the physical record of case number SCSC 200-826. This is where we're going to get into the rules. Pursuant to the best evidence rule, Rule 5.102, and this is why I tell people, when we're looking at this electronic record, this AI and everything that we're dealing with, this is a digital record, and it does not allow for blue ink signatures proving original physical contract or documentation. Doesn't prove that. Now, if they print one up and sign it in blue, that would be considered an original, even if it came from the electronic record. That's what we're trying to prevent, is their documents being a dismissal as a final judgment, being signed in blue ink and handed forth as if though that's what it is. They haven't handed over any blue ink signatures. Everything's been from a digital record with black ink. Ours are the only ones with the blue ink signatures. Anywhere. And the clerk's mandatory duty to keep original records at 602.8103. We are providing physical originals with wet ink signatures. Given the admitted failure of the court's digital recording system on January 26th. This is where I'm talking about that summary judgment that was supposed to be handed down, a strict statutory duty of mandatory presumption of retaliation, because the plaintiff got on the stand and testified they violated the Iowa Uniform Residential Landlord and Tenant Act. And they're the ones that admitted their violation. And that was our right to cure. our remedy. We sought remedy at that time, and they refused us remedy pursuant to that act. The digital record is currently compromised. We are exercising our right to a manual chain of custody to ensure the integrity of the record for the Supreme Court. I don't give a fuck about your records anymore. You've already proven your delusion that you are the boss. The clerk has accepted the filing requesting the audio in electronic form, but the recording remains on the magistrate's personal device. This is a bold statement, but it's only a statement to force their hand. Because now the request has been made and the rules of integrity, physical originals must be in the physical custody of the clerk. Clerk's mandatory duty to keep original records. That recording device is an original record. They have a duty to have that duplicated at least. The clerk has accepted the filing requesting the audio, but the recording, yeah, we just read that. We are requesting your administrative intervention to ensure this digital evidence is not deleted or altered. What we've already told them about before, 18 U.S.C. 1519. Mutilation or alteration of a record. Altered before it is handed over to the clerk for the Supreme Court record. We want to make sure that the record we're handing over to the Supreme Court is a true and correct record, not one that's been mutilated or altered. And if they hand us one that's mutilated or altered, this is our evidence showing their attempt to do so. Now the weight against them bears much more evidence, even if there's one tiny little mistake. Attached is a copy of the filing refused by the clerk specifically for the date-stamped chain of evidence. Date-stamped. Not a digital record stating a date. That's not a date-stamped physical chain of record. The record shows that on 3/3/2026, this court accepted the filing of the request for audio recording. Be advised that per Iowa Code 6028103, the clerk is exclusive custodian of all court records. We are preserving the paper record above and beyond the digital record for the physical evidence of date-stamped filings with signatures. See, if it's a digital record, they don't have physical possession in their filings. It's in a blockchain that goes out to everybody else and can be printed up. But if there's no evidence of the recording itself or the transcripts available, guess what? They're again hiding that evidence. They're violating my First Amendment in expressing myself and your right to know. The district court is not only shuffling the case to avoid a confession, but the clerk's office is actively refusing certified legal mail from a pro se defendant as evidenced by the attached date-stamped exhibit. And that's date-stamped by the Postal Service. Certified, green, return, receipt requested. See, they are now my witness. This court is conducting business. And under their competencies, they're supposed to have a knowledge, skills, and behaviors consistent with that. And if they're violating their own rules, that's inconsistent with the structure of the business that they're doing, particularly when that business is, again, the First Amendment as a matter of public record where a witness went on the stand and confessed in open court that they violated the Iowa Uniform Residential Landlord Tenant Act by not issuing the strict statutory mandatory duty of a 7-day notice to cure upon our original complaint of the upstairs tenant's excessive noise, which was the original cause. They enjoined that cause by not hearing our complaint and just moved forward with an eviction. And when they did so, we sent them a request for reasonable accommodations under the Fair Housing Act for a disabled tenant. And they denied that as well. So now we have them on the record twice failing the strict statutory duty of notice. And then when they moved forward with the eviction without giving us a 7-day notice to cure, they again violated the Iowa Uniform Residential Landlord and Tenant Act. 3 violations stacked up in one issue of bringing a claim and then admitted it on the stand, showing that they had a 12B failure to state a claim upon which relief could be granted because they confessed themselves. And this is now a conclusive record of evidence that they're trying to hide. As the trial on January 26, 2026 was recorded on a non-court personal device due to system failure, the clerk has a mandatory ministerial duty to secure the original digital file from the magistrate, verify the integrity of the file against the 45-page transcript, permanent storage, place the file into the official court record, not a private drawer. See, we're getting that into the digital record through physical paper documentation. And then we're going to get that transcript to back it up. We're waiting to find out how long that's going to take to get our transcripts right now. We paid for them a week and a half ago, if I remember correctly. Failure to take physical possession of this recording constitutes a breach of the clerk's duty to maintain the integrity of the record for the pending Supreme Court appeal. Note, an affidavit of refusal and motion for sanctions in order to show cause has been sent to the Supreme Court of Iowa in regards to this specific violation of our right to preserve a paper record. Blah, 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 respectfully. Let me check, make sure. U.S. Marshal or Sheriff, correct. If we end up going to the Supreme Court of the United States, it would be U.S. Marshal. As of now, it's just the Sheriff. And truth be told, yes, it is concealment. They are trying to hide the record. And I want to say greetings to everybody. And this record can also be used in higher court. I would have put them fool's name in the title. Well, that's why we addressed it to the chief clerk, Jackie Rath, and she's the one that denied it. See, she's the one with the supervisory duty, just like Chief Judge Kellyanne LaCar has a supervisory duty to know what all of the underlings under her are doing, along with the district clerks and all that. The chief clerk has a duty, supervisory duty, to know what all the clerks are doing under her. And like I said, we also gave notice to Lena Height. She's the associate manager, the district manager, okay, the district administrator. She's the one that has supervisory duty over the entire court, including the judges, okay? So we're giving her notices to let her know, and pretty soon we might have to serve her certified mail as well. But so far, we got the 2 green receipts back for our notice to the Judicial Qualification Commission here in Iowa in regards to the procedural legal errors, and the one that we sent to the Chief Judge, Kellyanne LaCar, wanting her to look over all this information and letting her know that we know her job as well, as to it's mandatory. She has to investigate as to why the adjudication was diverted. And in that, if she did her proper investigation, she would understand that it was because the magistrate presiding over the hearing falsely diverted it after the plaintiff got on the stand and testified that she violated both state and federal laws. That placed a strict mandatory duty of presumption of retaliation on the magistrate at the presiding hearing, Heather Feldkamp, who was then supposed to give a summary judgment in favor of the defendant for that presumption of retaliation against the plaintiff. The burden of proof now shifts to the plaintiff, and they can't refute it because they just admitted it. In the Supreme Court of Iowa, Keith Little and Joy Schmidt, affidavit of refusal of service and obstruction of the record. We, Keith Middle and Joy Schmidt, being of legal age and under penalty of perjury pursuant to the laws of the state of Iowa, hereby depose and state. Relation to pending appeal. This affidavit is filed in direct correlation to the notice of appeal and application for discretionary review filed in this court on 2/24/2026 regarding the final order of dismissal in Blackhawk County case number SESC 200-826. The refused filing on 3/3/2026. We attempted to file a request for original audio recording and filing of transcripts via USPS certified mail, addressed to the Blackhawk County Clerk of Court. The act of obstruction on 3/5/2026, United States Postal Service returns said filing to us. A true and correct photocopy of the refused envelope is attached hereto as Exhibit A. Structural evasion. This refusal constitutes a deliberate act by the clerk of the district court to prevent the inclusion of the plaintiff's judicial confession and the magistrate's personal recording in the official record, thereby obstructing our 14th Amendment right to due process and our right to a remedy under the Iowa Constitution. Notice to the Supreme Court. We are bringing this refusal to the immediate attention of the Supreme Court to document that the Blackhawk County District Court is actively shielding a civil rights violator by refusing to accept sworn filings and certified transcripts that prove a violation of Iowa Code 562A.36. Blah, 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 blah. Next one. Motion for sanctions in order to show cause. I want her to show a legitimate cause as to why she refused our demand for paper filing, wet ink signature, to hand a true and original copy over to her for mandatory custody of preservation of that physical record. Comes now the defendant appellant pro se and moves this court for an order to sanction against the Blackhawk County District Court clerk and for an order to show cause, stating in support grounds for sanctions. Obstruction of access to justice. As documented in the accompanying affidavit of refusal, the district court intentionally refused service of physical, certified legal filing containing trial transcripts and requests for mandatory audio records. Violation of ministerial duty. Under Iowa Code 602.8102, the clerk has a mandatory non-discretionary duty to accept and file documents. The refusal of certified mail from a pro se litigant constitutes a structural obstruction of the appellate process. It is that alteration and mutilation of a record by denial. Spoliation of the record. By refusing the filing, the clerk has facilitated the potential spoliation of a digital audio recording currently held on a magistrate's personal device, wherein, if that record is not duplicated sometime in the future, that record is deleted because there's no more room on the device, and she consequently needs to make room on it to record another hearing that will eventually be deleted? Nuh-uh. Not under my watch. This is in direct violation of the defendant's right to a remedy and due process. And we're going to get into the definition of meaningful hearing later on. The very definition of meaningful also set out in their case laws and giving strict statutory duties. Defiance of judicial mandate. This conduct serves to insulate a lower court that has already acted in defiance of the Supreme Court's mandate in State versus Paglia 2026. We're showing that their dismissal of our appeal, because it was moot, because they allowed a voluntary dismissal, but did so at defendant's cost, was in direct violation because they did so at defendant's cost, as well as the mention of the violation of the rules of procedure that they allowed a voluntary dismissal after the hearing was already had and the plaintiff admitted on the record of federal and state rights violations. Again, a due process violation by the plaintiff. Failure to bring a claim upon which relief could be had. Defendant appellant respectfully requests that this court issue an order to show cause requiring the Blackhawk County Clerk of Court to explain why a certified legal filing was refused. Order the immediate seizure of the digital audio recording from the magistrate's personal device to ensure the integrity of the record. Vacate the void assessment of costs as a sanction for the lower court's bad faith obstruction. See, we're not asking for anything other than the void assessment, which would vacate their dismissal, the final judgment in that case, because they are barred from doing so. That's the sanction. It's already written. What is done is what ought to be done. And you did something that wasn't ought to be done. Grant any further relief deemed necessary to restore the integrity of the judicial process. See, in this part here, we're not asking anything for ourselves, but expressing that if it continues, it too is a violation of 14th Amendment, and we will now include the clerk of court in that due process violation and name her specifically. Now we will start naming her. Double check with everybody, see how everybody's doing. You guys feel free to comment in the chat. Let me know what's on your mind. If you think I'm doing this for me or if I'm doing it for you, a greater good. See, we have a one-party case or a one-off type case, they call it. It's not actually that one-off. Like I said, this plaintiff got on the stand and admitted that she's been doing this property management stuff for 8 years. And all this time, she didn't know she had a strict statutory duty to give out that notice. How many people were violated in the past in wrongful evictions and didn't know it? See, that's the claim. I have a right to express our situation, but I'm guaranteeing you that everybody else's right to know includes all those people that had a right to know that already went through it and were denied that justice because they didn't know. So let's get back to it. The next one is motion for sanctions in order to show cause. This is the motion for sanctions in order to show cause. Did I just read that? Yes. What is this? Oh, that's just the address. Okay. What is... No, that's not it. So that's just the address I got to send it to for the Supreme Court. And there's the information in there to tie it to our appeal that we just made. There's a directive in there showing them to look at that. Let me... the Supreme Court of Iowa. We read that one. Read that one. So there's not as much as I thought there was tonight. No wonder it went through so quick. So anyway, that's what we're talking about, folks. From day one, the upstairs plaintiff violated strict statutory duty under the lease agreement, the rental agreement, to be respectful to his neighbors when it comes to a noise ordinance and keep it to incidental noise. Instead, they violated that with excessive noise, running, jumping, stomping, yelling, screaming, hollering all day from wee hours of the morning till the wee hours of the morning. Not every day consistently, but many times. And we went to them in private and asked them, and they said, sure, they understood. They quieted it down. They didn't. This went on for 2 weeks. They didn't want to listen. So then we went to the second witness, the landlord. They didn't hear us. and didn't follow their strict statutory duty to give the 7-day notice to cure to the tenant. Had those two parties done everything in good faith, be here. This is Titus 3:8. This is the faithful saying, that I will, that thou constantly affirm, that he who believe in God be careful to maintain good works. These things are good and profitable unto men. So in maintaining good works, I'm supposed to go to my brother in private, Matthew 18, verse 15, and give him notice of my ought first. This is the duty in law, is legal notice. First duty in law is legal notice. I know what I might be forgetting. Ah, yes. I forgot to copy it over in my docs. I knew there was one missing. Okay, you're going to have to deal with it in this form. But let's see here. Bring it back down here. Okay, this is the authorities that I was telling you about earlier. You're gonna see them in all the different jurisdictions, and this goes to the law is construed to be uniform throughout all jurisdictions. So all these different jurisdictions are going to state basically the same thing, but they're going to be different. So the best evidence rule under Iowa Rule of Civil Evidence 5.1002, and this is our strongest shield. The best evidence rule states that to prove the content of a writing, recording, or photograph, the original is required. The argument, a digital scan is a copy. A paper document with a blue wet ink signature is the unique, non-fungible original. In a case involving structural obstruction, the digital system, EDMS, is a very controlled environment that we are challenging. Therefore, the physical original is the only best evidence of our filing. Iowa court rule. This is the best rule of evidence. This is Iowa court rule. Exceptions to electronic filing. While Iowa generally mandates electronic filing, Rule 16.3052 allows for the non-electric filing for good cause. The good cause authority. Our good cause is the inherent unreliability of the local digital record, the failed recording system, and the need for permanent authentication. Under federal rules of evidence, I believe it is. I'll have to double check that. Let me double check that real quick. And I put the wrong thing up here. Federal rules of evidence, rule 803. I think it's yep. Let's do. I gotta shut my screen share down. Switch to a different panel. I'm not adept at this, so you have to excuse my time lapses here. But here we have Rule 803, exception to the rule against hearsay. Okay, this is the only place in this whole section that has anything about digitized thing. And it's under Committee Notes on Rules, 2017 Amendment. And it says, The committee carefully considered, but ultimately rejected, an amendment that would preserve the ancient documents exception for hard copy evidence only. A party will often offer hard copy that is derived from ESI. Moreover, a good deal of old information in hard copy has been digitized or will be so in the future. Thus, the line between ESI and hard copy was determined to be one that could not be drawn usefully. Thus, the line between ESI and hard copy was determined to be one that could not be drawn usefully. That's not what we're trying to draw. What we're trying to draw is that the digitized copy will clearly show that the plaintiff admitted on the record that she did not give notice of the 7-day notice to cure that she was required to upon our complaint, December 16th. And this will show in evidence because she responded with an email all across the tenants, apprising them of a rental agreement clause about an incidental noise ordinance. And again, this isn't incidental. This is excessive. We complained about it. They had a strict statutory duty to give a notice to cure, and they did not. That's a felony violation. All we got to do is bring her back on the stand. The record's been compromised. I know, and everybody in that court knows, that she admitted not to doing that, giving that 7-day notice to cure. I have a right to subpoena her to correct that record if it's missing in that record. That's the one thing that would only trigger the magistrate to take it under advisement. Otherwise, she still had a strict statutory duty to hand down a summary judgment, even if it was in favor of the plaintiff. Tenant upstairs failed. Plaintiff failed. The magistrate presiding over the hearing failed. Chief judge failed. District administrator failed. Chief clerk failed. Every last one of them failed. Every last one of them knows that a trial was had and that a summary judgment was supposed to be handed down. Let's look this up. 5 CFR 575.102. And I believe I showed you guys this just the other day as well. One of my recent videos. This is Administrative Personnel, Office of Personnel Management, Civil Service Regulations, Recruitment, Relocation, and Retention Incentives, Supervisory Differentials, and Extended Assignment Incentives, Recruitment Incentives, definitions. Competencies means the knowledge, skills, abilities, behaviors. When people in this building start behaving like true Americans again, I will shave this off. Until then, I'd like to remind you, we don't allow Hitler's willing executioners in these buildings. And other characteristics and individual needs to perform the duties of a position. So again, I'm not asking you to agree. I don't give a fuck about your opinion. You have a duty. That duty Office of Government Ethics, Administrative Personnel, 5 CFR again. And this is the Code of Federal Regulations. Both of these are Code of Federal Regulations. Okay? These are mandatory. Office of Government Ethics, standards of ethical conduct for employees of the executive branch. Public service is a public trust. They are in public service, and they are part of the executive branch using administrative processes to determine judicial qualifications. Each employee has a responsibility to the United States government and its citizens to place loyalty to the Constitution, laws, and ethical principles above private gain, to ensure that every citizen can have complete confidence in the integrity of the federal government. Each employee must respect and adhere to the principles and ethical conduct set forth in this section, as well as the implementing standards contained in this part and in supplemental agency regulations. And again, like I said, don't believe me, don't believe the neighbor, don't believe the government. For crying out loud, don't believe your mother. Do your research so you know. It says this in the federal code, and therefore it is construed to be uniform throughout all jurisdictions. There must be like language in your state codes, referring to like language in your state constitution. So let's get back to the other document, which is where we're going to talk about those constitutions and state codes. It is uniform throughout all jurisdictions. By filing on paper, we are invoking the court's duty to maintain a permanent record under Iowa Code 602.8103C. Iowa Code 602.8103, General Duties of the Clerk. This statute mandates that the clerk shall have the custody of and safely keep the original records. The argument is the legislature distinguishes between records and original records. Words have meanings, folks. So when Congress wants to legitimately try to say my records are different, are not of different quality, and no line can be distinguished, it's already been distinguished. Records and original records. The digital entry is a record, but a signed paper is the original. Therefore, they have to accept that even if I have entered in a document with or without a signature, I have the right to show its point of origin, and that is that it came from me. In other words, I have the right to write another document and actually sign it in blue ink. I have the right to copy that digital record and then sign it in blue ink. My name, according to the digital record. Nobody else can sign that name, except possibly another Keith Little that comes along and he's got the name Keith Little, but that still would be a deception. We are asserting our right to have the original kept in the clerk's physical custody to prevent digital alteration or shuffling. The constitutional authority is the right to an accurate record. The 14th Amendment Due Process Clause. The U.S. Supreme Court has held that a meaningful appeal requires an accurate, and that's why I said, be prepared for another video. I'm going to talk to everybody about meaningful and the definition of meaningful and what it relates to in case law, both federal and state levels. Requires an accurate and complete record. Griffin versus Illinois. The argument, if the digital system, the audio recorder, failed, like I said earlier, if that isn't preserved and that magistrate erases it sometime later because it's on her personal device and she just quaintly or obviously needs some more room to record the next hearing, she just delete the old ones? How does that work? Does she preserve those USB drives? Does she put them on USB drives and preserve them there? I don't know. I want to make sure I do know. I no longer live in belief, folks. I want a physical copy or a digital one sent to me that I can make a physical copy that will have that chain of record, that blockchain of record showing that it originated from that device. Again, this is FCC now. And we haven't mentioned them yet. If the digital system, the audio recorder failed, the digital chain of custody is broken. So I want that digital record to show that it's complete and accurate. I've got transcripts coming, and that should show that it's complete and accurate. But on top of that, I want to make sure that it wasn't already altered. If there's a failure in that transcript and it doesn't show the recording where that plaintiff got on the stand and testified that she did not give a 7-day notice to cure, I know the record is in error. All I'm doing is maintaining the evidence, and they're trying to deny me that maintenance. Once again, we are reverting to the manual chain of custody, paper, to restore the integrity of the proceedings. A wet ink signature provides a physical forensic link that a digital typed name, SS or /S/ cannot replicate. Iowa Constitution, Article 1, Section 1, inalienable rights. The right to acquire, possess, and protect property includes the right to protect the legal record that secures the property. We are choosing the most accurate. Secure method of preservation, paper, to protect our right to a remedy. Article 1, Section 6. Manual of superiority argument. When the clerk or judge asks why you aren't using the computer, you state. And that's as far as I got. And we're going to state why, if that audio recording is somehow erased or it glitched during the recording, and somehow the transcripts show that there is no confession by the plaintiff, we want to make sure that we can have a hearing where the plaintiff will come in and state in and on and for the record again that she is the one that failed her strict statutory duty upon a strict statutory duty of the plaintiff upstairs violating the rental agreement. They had a strict statutory duty to keep the noise down. They didn't. I told them about it. They didn't want to hear that. So I went to the property management about it. She failed to do anything about it, and then failed to do anything about our request for reasonable accommodation, and then filed a wrongful eviction, and then constructively converted it to the eviction and claimed a voluntary dismissal in favor of her, despite her confession on the record of violating state and federal civil rights. The court now has a mandatory duty to report misprision of felony, at least. When they turn around and start covering it up, we could call it misfeasance before. Now it's malfeasance, and they have a strict statutory duty because they've been noticed of that. And even though they want to argue that they didn't get the notice because it wasn't filed properly, some bullshit. They have physical custody of it, according to the digitized system. Yes. Go back and watch my videos. This is the 12th one I've done so far on the wrongful eviction. Started about 3 or 4 weeks ago. And you'll see I've been step by step explaining everything I've done and everything they've done. And I've explained everything that they've done wrong and showed case law and rules and ethics about it. This is why I say this isn't for the weak. And you certainly can't go around believing people anymore. So do your research so you know. Go back and watch the videos. I can't sit here and keep explaining it to everybody who wants to ask that one question. Go back and watch the videos. If you really want the information, you'll see step by step. And I'm proving them wrong every step of the way because they're violating state laws. I'm showing them the case laws that they're violating, that I've already set it down, everything. They have rules. They're supposed to follow them. They're not. In not following them, they're violating state laws. In violating the state laws and not hearing the record, they become the third person not hearing what the ought is when they ought to. What is done is what ought be done. There is nothing new under the sun. They already know what the law is because it's written down. That's the record. And that is a permanent record until they change it. And they haven't done so yet. They still have these strict statutory duties. No, why would I get an attorney? Why would I get an attorney? See, you guys have to understand words have meaning. And when you have the right to seek counsel, and they use the Miranda warning through case law to convert the language and convince you had the right to an attorney to represent you in a court of law, that's a representation. That bypasses your right to counsel. That bypasses your right to know. Ask the attorney that is sitting there representing you in a case a serious question and tell me how they don't sit there and look at you and say, shh. I've done it way too many times. I'm listening. I'm tired of listening to people to tell me, shh. I will not. I have a great freedom of expression. In that, I have a responsibility. And that responsibility is because the greater exponential right is everybody else's right out there to know. You want me to shh? Tell me to shh. Tell me to get an attorney and I'll explain it again. The exact same way I just did. You have a right to seek counsel. Immutable counsel. That means they can't mute the counsel. This is Hebrews 6:13. All you Christians out there, that plays in there with Titus 3:8 and Matthew 8 or 18 verses 15 through 20. See, I went to my brother in private. It's what I ought to do. That's what it says to do. What is done is what ought be done. There is nothing new under the sun. And then I went to the second witness in private. They didn't hear me either. And then I was brought before the court, and the court's not hearing me either. You want me to shh? We're going to find out. We're going to find out because I've hollered out to HUD for a civil rights violation, the Iowa Office of Civil Rights for a violation at state level. HUD is at federal level. IOCR is at state level. HUD is the Fair Housing Act. Iowa is the Iowa Uniform Residential Landlord and Tenant Act. And then we reached out to the Judicial Complaint Commission to let them know of all these procedural legal errors. And then they finalized a dismissal against state law. So we filed an appeal with the Supreme Court immediately. And now we're issuing a motion for sanctions and all of that. In our appeal to the Supreme Court, we proposed an order to send it back to the district court to have them re-adjudicate according to the mandate. In other words, in order to fulfill their duty without sanctions, they must hand down the summary judgment in favor of the defendant because the plaintiff admitted to a 12B rule violation, failure to state a claim upon which relief could be had because they confessed conclusively on the record that they violated state and federal laws in denying the notices properly because they didn't know, and that they'd been doing this for 8 years. Ignorance of the law is no excuse. Yes. And so we're also reaching out to the Institute for Justice. And I don't know if you guys know anything about the Institute for Justice, but they love people like me that won't shh. They love people like me that will go to the news media and tell them all about it. They will put me in front of the cameras to speak all about it. That's not necessarily what I want. I would rather just people come see me here through this media. But if that's what it takes, I'll do that. I'll go through the Iowa Institute for Justice and have them help me speak out in the media. Maybe they can help the voice be heard, the message. Because it's not about me. Yeah, we're going through this eviction, but again, how many other people have already gone through this and didn't know? How many people will go through it in the future if they silence us? Whereas if I speak out and people do hear it, maybe they'll help learn themselves. Maybe they will do their research, because I'm going to reiterate again, don't believe me. Don't believe the neighbor. Don't believe the government. Don't believe your mother, for crying out loud. Do your research so you know. That's the only way I'm doing this. I have to sit down regularly and do research on this stuff, because a lot of it, I have to refresh myself and become very familiar with Iowa rules. I already had one case dismissed, failure to appear for jury duty. And again, that case too was dismissed at cost to defendant in violation of state law. When Paglia, State versus Paglia was decided January 9th of 2026, just this year, just a month ago, or excuse me, just 2 months ago, they determined that by Iowa law, it was against the law, meaning it was already against the law. It was already mandated that they could apply the cost to the plaintiff, but nowhere did it say they could apply the cost to the defendant. That would be at the defendant's detriment in a case dismissed. If they are not being held accountable, but the costs are at the defendant's expense or taxed to the defendant, as it said in my dismissal for failure to appear for jury duty, then how is that not detrimental to the defendant who had nothing to do with it, who can't be held accountable? Proving they are innocent, and then you're going to tax the cost to them? That just doesn't seem right. It just doesn't seem right ethically. And I'm amazed it had to go to the Supreme Court of Iowa for you fucking insane control maniacs to understand that. It's the same fucking thing as debtor's prison. That's why I say, not until I see those people in those buildings acting like true Americans will I shave this off again. We do not allow Hitler's willing executioners on American soil, people. Do you want me to... Very unconstitutional. Very unconstitutional. Micah Ellen, again, I want to welcome everybody. I think the issue was the merger of common law and equity as well with these statutory administrative courts and venue. Yeah, see, that's the problem. These administrators, these administrative law judges want to step in and say, well, we're administrate this equitable action. No, you're founded when a landlord brings you into a use and possession, which is an equity title. They are holding legal title, and they want the court to determine that by their legal title that they can show through preponderance of doubt or preponderance of evidence that the defendant did in fact violate whatever agreement that caused them to come to court to seek equity, an equitable action. Equity, which is use and possession. In other words, they wanted to get me out so they could put somebody else in under a rental agreement, which is their intent and purpose of the use of the legal title, is for business. Whereas mine, use and possession, is a matter of necessity of life. This is your equity title. Necessity of life. Has nothing to do with emotions. It has nothing to do with reason or logic. It has to do with nature. And when they try to eject somebody under common law through using an administrative statutory code of eviction, that too shows that they brought a claim in the wrong court. They sought an equitable action under statute. Therefore, they were supposed to bring it to an equity court And that's what small claims is. It's an equitable action, forcible entry and detainer, which is the legal title, entry and control. Equity title is use and possession. So again, people, don't believe me. Don't believe the neighbor. Don't believe the government. For crying out loud, don't believe your mother. Do your research so you know. You will see how this stuff works and interplays. And again, I'm urging many of you to unlearn the shit they taught you and relearn. And this includes English. Get yourself a concise English handbook and a college composition handbook so you can literally see the grammar changes in all of these different documents that they try to use. Let me pull up. I got a physical copy of the dismissal at defendant's cost. We're going to show you something here. Well, my apologies, folks. This is what happens when they make you do too much documentation. This is bullshit. This should have ended on the 26th of January. That magistrate should have handed down a summary judgment in favor of the defendant. And here we are 2 months later, or a month and a half later. And a stack of documents filed with everyone denying him, everyone dismissing them. Bear with me, folks. I'll be damned. Let me take one more. Here we go. Okay. This here is, let's see, 24th of February, 2026. This is the final dismissal, and it was handed down by Stephanie C. Rottenborg, District Associate Judge. It's when I spoke about in my last video. MGT Property Management says defendants filed a notice of appeal on February 19th, 2026. However, plaintiff voluntarily dismissed the case without prejudice on February 2nd, 2026. However, this document in digital form with her signature, okay, would propose to be a true and accurate record. However, that would be false. See, I have a right to a true and accurate record, and this here poses that our appeal was denied because the plaintiff voluntarily dismissed it, and therefore it was moot. That's what they go on to say. It says Iowa Code Section 631.13. limits appeals to a judgment in small claims. A voluntary dismissal without prejudice is not a judgment in small claims. How is it not a judgment in small claims? Because it's a voluntary dismissal and no summary judgment was handed down. And that's how. But it goes on to say plaintiff's voluntary dismissal rendered this case unreviewable, effectively wrong, terminating this court's jurisdiction over the matter. No, wrong. In the record, like I said, the plaintiff admitted a 12B rule violation, failure to state a claim upon which relief could be had. Therefore, denying the court of jurisdiction to begin with, and admitted that on the court record, and now the court is trying to hold the record from me. I demand that record so I can file the civil rights claim and have supporting evidence thereof. If they're denying me that record, then I have to bring the plaintiff in and have her get on the stand again in a civil rights case, where she might just say, well, no, and then try to produce records. We're not going to have that. And in order to help ensure that, we're just merely maintaining our right to an accurate record, and this one is not accurate, as we've already shown. The court had no place to put a final dismissal in violation of state law, nor did they have room to accept a voluntary appeal by the plaintiff after the hearing was already held, pursuant to the rules of civil rules of Iowa, and the clerk had a duty. The clerk had a duty not to allow that false record to be entered. That's all we're doing. And every last one of them is proving themselves guilty every step of the way. Let them lie and lay that rope that will tangle them all up. I've said this before. See, if you want me to shh, I'm not going to do it. I'm not going to do it. So if you've got the ears to hear, I hope you're listening. Because ain't nobody else going to tell you. How are they going to tell you if they're not going through it and showing you step by step what's going on? Yeah, and see, that's another point. A voluntary dismissal needs to be consented by both parties. Absolutely. Especially if in the interest of the defendant, where defendant is in need of protection. Because the plaintiff admitted to those statutory violations and now shows that they weren't protected. And that dismissal goes on to say that the rights of the defendant or the defendant received the best adjudication they could. Another falsity. Because of the very violation, conclusive evidence in, on, and for the record, we hope. So all we're doing now is waiting for the transcripts. I've got an email out waiting to hear back how much longer it's going to be. And when I get them, I'm going to read them off. And if there's anything in error, I'm going to be making notes on it, particularly if that admission isn't there. If that admission's there, I'm going to take a breath. Because then it's on documentation. Then it's on paper record. Not until then. But that doesn't But that doesn't belay them their duty. I'm still pushing for that. Because like I said, that whole stack of paper, almost a full ream of paper now. I'm not fucking around. This is everything I filed. Letting them know in every situation, every step along the way. And every bit of it is nothing but truthful and factual details that they're supposed to know. They're supposed to have the competencies. Knowledge, skills, abilities, behaviors, and other characteristics an individual needs to perform the duties of a position. So anyway, that brings it to the end for me. Went a little bit longer than I actually thought, even though I at one time thought it was going to be kind of short. But I found that other document, and of course the details there. Like I said, folks, it's uniform throughout all jurisdictions. Just find all the different jurisdictions that are available to you. Like I said here, the rules of evidence, their judicial canons, things like that. So, and that's what we're talking about in this case in regards to that request for audio recording. Is that one of the judicial canons is that meaningful hearing and the accuracy of that record. And when we were denied the court reporter, that magistrate pulled out a personal recording device. Always question that. Always. Always. These people are so corrupt. Like I said, she was supposed to hand down a summary judgment on the spot. She didn't do so. So think about this. And remember, there's a PayPal link down below for anybody who wants to share some love. And remember, I love you, but I don't give a rat's ass whether you love me back or not.
Man up, slaves, and hit those buttons, or I'll send ice.